welcome to the National Civil Rights Museum. We are honored to have you physically here and joining us virtually. My name is Russ Wigginton, and I have the honor of serving as the president here at the National Civil Rights Museum. This conversation, this dialogue, this discussion is an aspect of our work here at the National Civil Rights Museum where we honor the legacy of Dr. Martin Luther King Jr. and tell the story, the ongoing story of the American Civil Rights Movement with a goal of educating and serving as a catalyst for positive social change. We do that in many different ways. We do that through our exhibitions, we do that through our workshops, and we certainly value the opportunity to do it through rich discussion with brilliant, thoughtful, and bold people. Tonight is one of those occasions when you are going to get the opportunity to hear from some brilliant legal minds and a journalist who has had a remarkable career. We do this because there are multiple dimensions to what a just society looks and feels like. We do that for people to understand the history of this country. We do that for people to understand and recognize our role today in making for a more just society today and tomorrow. Sit back and relax, enjoy, and participate in this wonderful discussion. Thank you.
Well, thank you so much for partnering with us and for your hospitality. My name's Ari Middleman. I'm the executive director of Keep Our Republic. And I'll admit this is the first time I've been to Memphis. I'm super grateful for this partnership, particularly because of the 70-degree weather outside, which is quite different than what I left this morning up north. The private tour earlier today, I'm still quite emotional from it. And I read on the walls just down the hall the preamble of the Constitution. And many of you have asked me, what is Keep Our Republic? I think many of you just heard of this organization when you got the invitation for tonight. And Keep Our Republic, we're a nonpartisan civic education nonprofit. And I say all that because and we began back in the spring of 2020. So among other initiatives, we're fortunate to have a diverse group of retired federal judges from across the country appointed by presidents of both parties, some of whom that you're going to hear their incredible perspective tonight. And they're wonderful volunteers, and I'm just so grateful that they've joined us from near and far for tonight and similar events we're doing nationwide. So our group's name comes from the Constitutional Convention, and many of you probably have heard this story, that it's rumored on the last day of the convention, many, many years ago, on the street corner there in Philadelphia, after a very long, hot, contentious summer, Ben Franklin was walking out of Constitution Hall, and folks said to him, essentially, maybe in Memphis, they would have said, what were you all doing there? But essentially, what type of government? We knew that you guys were debating, what type of government were you up to? And he immediately replied, looking them in the face, he said, a republic. And then he paused, and he said, if you can keep it. I think each of you joining us tonight, taking your valuable time, being engaged in the community is a demonstration that you believe, as we're in our 250th birthday, in the promise of America and knowing that the best is yet to come. So I'm also reminded, I did a quick lookup, just like I said, I learned so much about Dr. King today doing the incredible tour, that in May of 1965, just 2 short months after the Edmund Pettus Bridge and just the violence that transpired there, really the breakdown of the rule of law, Dr. King paid his first and only visit to my alma mater, University of Pennsylvania, and its law school. And I say that because I pulled up what he said to the Philadelphia Inquirer, the local newspaper, which is a great publication. And he said, May of 1965, just 2 short months after Edmund Pettus, justice at times proceeds with a halting gait, and the law has often been slow. And I think we're going to talk about exactly that tonight. But what he wouldn't have known, and that's we just never know what the future is going to hold in these historic times, just 3 short months after the Voting Rights Act was signed into law in August of 1965. So this partnership with the museum has been fantastic. On behalf of our board, many, many thanks. So grateful. I know there's folks literally from Seattle to Boston joining us online, and look forward to a really great discussion. We're doing events like this around the country, but I think this one here at the National Civil Rights Museum, as we're winding down Black History Month, is going to be particularly memorable. So thank you, thank you. I'm going to welcome colleagues to the stage, and I'm also going to welcome everyone. There's going to be a robust discussion afterward for those of us here in person upstairs, and there's also great food, I hear.
Good evening, everyone. Good evening. I want to offer my thanks to the National Civil Rights Museum for being the host this evening. Thank you so much for your hospitality. My name is Otis Sanford. I am Professor Emeritus in Journalism and Strategic Media at the University of Memphis. I'm also a local columnist, commentator, and political analyst. Also, I'll add that during my career, lengthy career in newspaper journalism, I covered the federal courts and the U.S. Justice Department for about 7 years. So I have an abiding interest in this issue, in this topic, that has stayed with me some 50 years. And so I'm honored to have been asked to serve as the moderator this evening. We are here for a timely and necessary discussion about the historical role of the federal judiciary in a functioning democracy. Also, the imperative that we have to make sure that this democracy stays intact and the rule of law stays safe against any attacks, verbal and physical. It's not hyperbole to say that we're at a critical juncture in our society. As tonight's co-sponsor, Keep Our Republic, so eloquently stated on his website, we must meet these challenges before they become crises. And I will add, crises that threaten the very fabric of our democracy. So it's fitting then that we hold this discussion during Black History Month and at this facility, the National Civil Rights Museum. So let me ask each one of our distinguished panel to introduce themselves, and then we will get right into the questions, and I will start with the Honorable Judge Bernice.
Thank you very much, Otis, and I join others in thanking you for being here this evening and thanking the Civil Rights Museum for hosting, and I want to thank Keep Our Republic for their partnership and for the drive for this program. I am Bernice Donald. I am a retired federal judge as of January 2023, and I sit here tonight as really a grateful beneficiary of the efforts of the people in this, who are mirrored throughout this museum, who sacrificed their time, their talent, their blood, their very life, that I might have an opportunity to ever dream of becoming a judge. And I know Judge Gina Higgins here tonight shares that same thing. I served as a United States District Court judge, and we'll hear about some district court judges of the past tonight. I served as a United States bankruptcy judge. I served as a General Sessions criminal court judge, and now I'm serving as neutral with the Judicial Arbitration and Mediation Service. And I am a member of the steering committee of the Article 3 Coalition, which is a partnership entity with Keep Our Republic. Thank you.
Next, we have the Honorable Allison Duncan.
Yes, and I'm going to continue what may become a tradition of expressing thanks to all of you for being here, for the exceptional job that the museum has done in welcoming us. But I would also like to add my personal thanks to Judge Donald, who is a friend of longstanding, who has done yeoman's or yeowoman's work in putting this conference together. And I have a bit of a grudge to pick because I'm hosting the next one in Raleigh, North Carolina, and I'm not sure I can live up to it, Bernice. I am from Raleigh. I live in Raleigh, North Carolina. I served on the state bench in North Carolina, and I also served on the Fourth Circuit United States Court of Appeals, which is based in Richmond, the seat of the Confederacy, and you cannot drive down Monument Avenue without being reminded of that. I was the first African-American woman to serve on both of those courts, and I am determined to not allow the progress that we have made as a nation to be eroded. And one of the ways to do that, I believe, is through education. So thank you for being here to help us learn, help us communicate with you, and continue the struggle.
Thank you. Honorable Jeremy Fogel.
Good evening. When I was asked to do this, I really was, quite honestly, overcome with emotion for a lot of reasons. I visited this museum probably a dozen years ago. We were talking before we started the program about places we've been in our lives that are cathedrals. They're places that sort of symbolize something really meaningful and deep. And my experience visiting this museum back then was like that. It was unforgettable in so many ways. And so to be back here again doing a program is particularly meaningful. Judge Donald and I have been friends for 25 years. It's wonderful doing things with her, and I join in the thanks to her for making this happen. I was a U.S. District Judge in San Francisco. San Jose actually is where I lived, in Northern District of California. In 2011, I came to Washington, D.C. to run the Federal Judicial Center, which provides education and research for the entire federal judiciary. I got to know judges from all over the country, and in that capacity, I met Judge Giles, I met Judge Duncan, and so many other people, and developed a very, very deep appreciation for how important our federal judiciary is and how lucky we are to have it. And so I'll be talking some about that, but mostly I just want to express very deep gratitude for being here.
And finally, last but not least, the Honorable Judge James Giles.
Thank you. Thank you. It's my great honor and privilege to be here with you tonight. Thank you for the invitation. I treasure it. Indirectly, I have a connection to you, one that helped bring me here. I was a law school classmate of your Judge Jeremy Bailey, class of 1967. So I wouldn't have missed this opportunity. I'm from Benjamin Franklin's hometown, Philadelphia. In 1979, I was appointed by President Jimmy Carter to the Federal District Court in Philadelphia. I served for 29 years, 7 years as Chief Judge towards the end of my tenure there. I am not a native Philadelphian. I was born in rural Virginia, the middle of the state. My first memory of a school, a public school, was a segregated public school, a one-room school taught by my grandmother. So when I reflect on my ability to be here today, coming from those beginnings, I say it only could have happened in America. And it only could have happened as a result of the civil rights movement and all of those heroes that you see and celebrate today. Many that you don't see. I was impressed by the background that showed all of those figures that are hard to see, but they are there nevertheless. And those are the forebears of those who did carry the cudgels of freedom and who today also struggle for recognition of full civil rights.
Thank you so much. Before I start with the questions, before in case I forget it at the end, I want to ask all of us to give an applause for our panel's service and also their accomplishments. Let's thank them. So I want to start by asking each one of you to briefly discuss why this topic is so critical at this moment, particularly within the context of the vital role that the federal judiciary played during the civil rights movement. In other words, why should we care about the issues that are confronting the federal judiciary now? And Judge Giles, I want to start with you.
Well, we would not have the cases upon which we rely for our freedoms, our constitutional rights, were it not for judges and justices who honored their oaths of office to be fair and impartial, exercising judicial independence, which means deciding cases without fear or favor, no matter what the economic circumstances are of the parties, and without regard to the personal investments of the parties before the court. Deciding the case based on the facts, the law, applying the Constitution, and all of the laws pertaining to the case and deciding the case. So the history of many of the cases we rely upon demonstrate often lower court decisions which were contrary to what we think of as independent decisions. And the Supreme Court of the United States recognized the obligation to the Constitution and to their oaths. So we have, for example, Brown v. Board of Education. There was only one case in the series of cases that went to the Supreme Court that had ruled that segregated schools were unconstitutional, and that was from Delaware, and it was a Chancery judge who decided that. And Chief Justice Earl Warren may not have been thought of as the ideal person from the school children's side to be in that mix of decision makers, because he, as governor of California and as Attorney General in California, had promoted the internment of Japanese Americans. But he saw, I'm sure, that his obligation as Chief Justice of the Supreme Court was to the Constitution. And he recognized, I think, that any other decision but the one that was made would have been a political decision contrary to the dictates of the Supreme Court of the Constitution, that is, the Equal Protection Clause of the 14th Amendment.
Judge Fogel?
So I agree completely with what Judge Giles said. I want to talk about, in this moment here, three district judges. Actually, one of them later became, two of them became circuit judges later, appellate judges, who did exactly what Judge Giles was just talking about. They followed the law. They respected the Constitution. They stood up for the principles of the Constitution at enormous risk to themselves. So Judge Wadis-Waring in South Carolina he had an epiphany. That's about the only way you can describe it. At some point late in life, and he was a white Southerner from South Carolina, and he believed in the prevailing views, and he realized that there was something wrong with that was not consistent with what the Constitution guaranteed, and that he, as a judge, was not something he should follow. And he began to speak out in his rulings. He began to assert. In fact, one of his cases ended up being part of the body of case law that influenced the decision in Brown versus Board, even though he had gotten overruled by Judge Duncan's former court, along the way. But this is somebody who really said, look, the Constitution guarantees equal protection of the laws. We're not getting it. We need to be specific, and we need to be concrete in the way we do it. Well, needless to say, he was completely ostracized in his hometown. Nobody would talk to him. His family was isolated. We'll come back at some point later on in this evening and talk about what's happening to judges now who make certain kinds of rulings. But it was the 1940s and 1950s version of that happened to Judge Waring, and he was basically like a non-person in his community for a long time. Extraordinarily brave, and it was all anchored in the Constitution. So now I love this, because if you visit Charleston, South Carolina, and you go to the federal courthouse, you know who it's named after? It's named after Judge Waring. So there's a real progress that's shown there. So another one who Ari Middleman mentioned, the Selma March. The judge who permitted that march to occur, after there were tremendous efforts by local law enforcement to prevent it, was a judge in Alabama named Frank Johnson. And he did pretty much the same thing. He just said they got a right to demonstrate. It's in the First Amendment. As long as they don't break the law, they can go to Montgomery and make their case. No one ever talked to Frank Johnson in the white community either after that happened. And there was the same thing. There was the ostracism and the threats, and yet here is a guy who stood up for the rule of law. I always love it. There's in the movie about Selma, he's played by Martin Sheen, and I can never stop confusing Martin Sheen with the President of the United States, but that's another story. And then one other person I'll mention, his name was Robert Vance, and he was another judge in Alabama who was both on the district court and on the what was then the Fifth Circuit, now the 11th Circuit. And he was assassinated. He's one of several, I think there were three federal judges in the 20th century who were assassinated. And he was targeted because of his support of racial equality as well. So these were people who literally put their lives on the line to support the rule of law. And I just think it's important that we recognize that's a real statement. These people were not crazy. This is a statement of how important these principles are.
And Judge Duncan, why is this important now?
I have to first comment on Judge Fogel stealing Judge Waring, who is from my neighboring state, South Carolina. You come from California, but all right, a good purpose was served. I do want to, though, mention Judge Waring's wife was spat on. in public. There were bricks countless numbers of times thrown through windows of his house. It goes beyond ostracism. It was venomous. And because I no longer have that story to tell, I will share another story that I speak about a lot because it is so very meaningful to me, and I talked about it a little bit this afternoon. I grew up in Durham, North Carolina. The Ku Klux Klan used to march in our Christmas parades. And my hero was Julius Chambers. He was one of the first African Americans to graduate from the law school at the University of North Carolina and order the coif at law review. And he went on to become one of the greatest civil rights lawyers ever. He argued the landmark school desegregation case of Swan versus Charlotte-Mecklenburg school system before the United States Supreme Court. And when he was preparing to make that argument, he was told by the Legal Defense Fund, when you get up in the morning and get ready to come to work, leave the driver's side door of your car open. Why? No, if there were a car bomb, he might escape death by being blown out the side. That is a lesson I did not grow up having to learn because of lawyers like Julius Chambers and because of the integrity and the independence of judges like the ones that Jeremy has mentioned and the ones that made all of our lives more meaningful because they believed in the promise of the Constitution. That is the oath that we take when we become lawyers. And we probably need to repeat it on a fairly regular basis to keep it at the forefront of our mind. So this is an opportunity for all of us to do exactly that.
Well said. Judge Donald?
I'm not going to talk about the judges that Jeremy talked about, but I agree with everything that's been said. And I know we here in Memphis have our own legends. Ben L. Hooks, who had an historic career and was faced with death threats. He became a judge. H.T. Lockhart, James Swearingen, Odell Horton, whom I succeeded on the bench. But you say, why is it important? I think it's important because, but for courageous judges to interpret and apply the law, we wouldn't really have the rule of law. I have traveled around the globe working and teaching in foreign countries, and there are a lot of countries with good, strong, worded laws. But I remind people that laws are not self-executing. They are not. It is only because of those judges who have the courage that we've already seen demonstrated to apply the law and call it for what it should be. Keep in mind that our Constitution, as one of its first covenants, talks about justice. And how many years did we have injustice in the streets and courts and hallways around this country? Because we say justice doesn't mean that we do justice or that justice will be done. And it is important for judges who take that oath to apply the law and to do it whether the person is a person of means or of no means, whether the person is a Latino, a white, African American, or otherwise. And I want to tell you this because sometimes we think about only people of color craving for justice. When I became a General Sessions judge, the first African American woman in the history of Tennessee to serve in that position, on my investiture that day, had a big ceremony in the morning and a docket in the afternoon, 4 cases, traffic. The first case on my docket was a young white male. He walked into the courtroom Chief Davis, he looked around and this is what he saw. I was there in an elevated position wearing my black robe, ready to do justice. Right below me were my 2-minute clerks, an African-American female to my left, and African-American male to my right. At a 45-degree angle on the floor was a prosecutor, an African-American male, and ringing the courtroom was the security team. 4 Shelby County deputies in uniform, 1 African-American female, and 3 African-American males, each armed with a standard issue Smith & Wesson weapon strapped to his or her side. And we were open for business, open for justice. That young man walked toward the bench when I called his name, and his eyes grew larger as he got closer. He came with fear and trepidation. And when he got there, he asked me for a continuance. And I want to remind you that traffic violations in Tennessee do not carry the death penalty. He came up shaking with fear, and he asked for that continuance, which I granted. And 30 days later, he came back to court with an African-American defense attorney. Now, that might have been the attorney he was going to hire anyway. I don't know. But I suspect he was concerned about whether he could get justice in a courtroom where there was no one who looked like him. Look at the years, the dozens of years that African Americans all across this country entered courtrooms hoping for justice and believing in their hearts that they were not going to get it. Not because they didn't have cases of merit, but because race, socioeconomic status, and other things provided a barrier. It takes judges of courage, judges who are willing to be impartial, no matter the person standing before them. And it's not just at the Supreme Court, it's in courts all around the spectrum, even traffic courts on which Judge Dorse sat, and I sat for a time. That's why that black robe that we wear symbolizes our commitment, our oath, to fulfill those laws, interpret them fairly, and apply them to every person entering that courtroom. That's why it's important.
Absolutely. When you talk about Brown versus Board of Education, a case that was decided in May of 1954, there's a parallel to the reaction to that case to what's going on right now. That decision, especially in states in the South, was totally ignored. I'm from Mississippi, and it took another 16 years before schools in Mississippi, public schools, were fully integrated. 16 years. And now we see rulings by lower courts that are being ignored. What is a lesson that we can learn from just outright ignoring cases, and what can we as a society do about it? And Judge Fogel, I'm going to start with you on this one.
Thank you. Well, I was just asked about this in an interview yesterday, and I think where it's really happening is in the immigration area, because there are so many of them, because of the policies of the current administration to deport a lot of people. But there have been orders made by numerous district courts, dozens of district courts, saying before you deport somebody, they are entitled to a hearing. You know, I always say there's 3 pillars to the rule of law. People say, what's the rule of law? Well, one of them is you have decisions that are based on evidence and legal principles rather than what somebody looks like or who somebody knows. And the second one is you have a right to a hearing. You have a right to make your case, and the third one is that you have an honest decision maker. You have a judge who is ethical. Well, what's been going on in many of these immigration cases is people are not getting hearings. Like the judge will say, show cause 2 days from now why this person should or should not be deported. And by the time the hearing comes up, the government comes in and says, well, this person's not here anymore. They're in Texas, or they're in Venezuela, or they're in El Salvador. And then the judge says, well, what happened? I mean, I said they were supposed to be here to have a hearing. Well, they were unlawfully undocumented aliens and they've been deported. Well, we haven't had a hearing yet. We haven't had any kind of due process. And this is playing out all over the country. And it's interesting to me because I think some of the most eloquent comments about this have been coming from very conservative traditional judges. So I'll steal again from you, Allison. Judge Duncan has a former colleague named J. Harvey Wilkinson, who wrote I think, a profoundly brilliant opinion in the Abrego-Garcia case. If you remember, Mr. Abrego-Garcia was the guy who was sent to El Salvador before he had any kind of due process. And Judge Wilkinson wrote a really pithy and brilliant opinion saying, we can't do that. You know, maybe Abrego-Garcia is a bad guy. Maybe he should have been deported. Maybe everything they're saying about him is true. But he's entitled to a hearing to establish whether it's true or not, and he didn't get one because of the actions of the government. And then the other one I'll mention, and I could mention a lot more, but the other one that I think really makes my point, there is the chief judge in Minnesota is named Patrick Schultz. He is also a very conservative judge. He used to teach at Notre Dame. He left Notre Dame for another law school called St. Thomas because Notre Dame wasn't traditional enough. His star pupil at Notre Dame was Justice Amy Coney Barrett. I mean, she was inspired by him. And Judge Schultz got a similar situation in Minneapolis where he said, I need to have a hearing on this person who the government is trying to deport. And the government came in and said, well, he's in Galveston, Texas right now, or he's in Honduras, and then he said, you got to bring that guy back so we can have a hearing. And so the judges are being pushed to a point where they are threatening the government with contempt. And, I could spend half an hour talking about contempt, but contempt is actually a very rare remedy. Judges hardly ever do it. It's very hard to do it correctly. And so for people like that to be pushed to a point where they feel like they need to invoke the contempt power, that is a crisis for the rule of law. And I give these judges enormous credit for recognizing that and being assertive about it.
Anyone else want to weigh in on, the fact that court rulings, court orders are being ignored here?
If I may, I do want to, Judge Wilkinson was a Reagan appointee, and he's individualist. Nothing offends him more than having a majority oppress the rights of an individual. And I at one point memorized the end of that opinion, which went something like this. The executive may ignore the words of the courts for a time, and eventually the prestige of the courts will suffer. But at the end of the day, and I think I've got this right, the law may die. The rule of law may die, and the law will write its epitaph. It was just, if you ever want to read probably one of the most beautifully, profoundly written opinions I have ever read, I commend that one to you. And I also want to draw to your attention what you have probably noticed as a parallel here. We were at the lowest rung of society for a very long time, marginalized, mistreated. Who has that role now?
Yes.
The most vulnerable among us. The rule of law is defined. Democracies are defined by how it treats the most vulnerable among us. So what are we saying about ourselves?
And I just want to add just one thing. We talked about the judge's orders being ignored. And when they're not being ignored, judges are now faced with threats of impeachment because people disagree with opinions they make. And we have an elaborate appellate structure, but people want to go right from certain entities want to go right from and ignore the appellate process and go right to getting the public riled and poised to impeach judges or demand the impeachment of judges.
And to add to that question, and you sort of touched on it, Judge Donald, there seems to be no reluctance at all to just spew vitriol against judges in ways, and I understand what happened with Judge Waring and Judge Johnson and others in the past. But now we are getting the same kind of vitriol from people who are elected officials, to the point where judges are being called radical and stupid and dangerous. And can you talk about a little bit about how that really hurts the administration of the rule of law?
You know, I would say that those kind of things are designed to undermine public trust and confidence in the judiciary. And if you undermine the courts, where people need to go to resolve disputes, where does that leave us? You know, the judiciary has no army that it can deploy to execute its orders. It doesn't have the power of the purse. It exists with that moral authority and the legal authority, really, to interpret the law and apply it. And for people who live in an ordered society and who respect the rule of law to abide by that and to resort to the appellate process if they disagree. If we undermine that process, then we have really kicked over one of the pillars of the rule of law, which really threatens our entire society.
I want to just add two things, if I might. So one is a negative thing and one is a positive thing. So the negative thing is this is a playbook that we've seen, and all three of us have done a lot of international work. And I was in Turkey before its judiciary was degraded. I was in Hungary before its judiciary was degraded. Wasn't in Poland before that happened. But I'm just three countries I'm just picking out where an authoritarian government decided they could expand its power by tearing down the judiciary. That was really one of their critical strategies. And it succeeded in Turkey. It succeeded in Hungary. It didn't succeed in Poland because the judges and the public pushed back. And the Polish story is really an interesting one because they're not out of the woods, but nor did it go as badly as in the other two countries. The positive thing I want to say is that I think we are more resilient. I think our system is stronger. We have a stronger tradition of judicial independence. We have courts that have, I think, weathered the current storm really well. I mean, judges have stood up and they've made their rulings. They don't always last on appellate review, but at least they're willing to say, look, I'm here. You can threaten me. You can send pizzas to my house. You can call me a dangerous radical. I'm going to follow the law. And I think that's been quite an exemplary performance by the lower courts.
Anyone else want to weigh in on that? Because I want to make sure I leave some time for some takeaways here for the audience. But Judge Giles?
Well, judicial independence is not only the burden of the judges who accept the role, it is the responsibility and the burden of you, we the people, to speak out when you know that that is going to undermine your right to a fair trial, not in a particular case, but generally speaking. We have lived in this country where we experience what it is to know that you're not going to get justice in a righteous case. We have lived that. This museum talks about that. I was about the same age as Emmett Till when he was brutally killed. And when those who killed him were in a courtroom that expected a result that was without respect for the concept of judicial independence. We don't want to go there again. You don't want to go there again. And so it's important that we all understand the concept of separation of powers and judicial independence, rule of law, that these are meaningful concepts. These are things that are bread and butter that get down to how you and your children and your children's children are going to live. And so that's what I have to say.
Yeah. Go ahead, Judge Duncan.
Two quick postscripts. One is I wrote an article for a magazine called Judicature called The Thousand Robes March. If you Google it, it is about judges from all over Europe and all over the world, actually, coming together to march in Warsaw to say, this cannot be. And the other thing is, we've all said that we've been very active in international circles. I was president of the region of the International Association of Judges that includes Asia, it includes North America, it includes most of the world, actually, except for Europe, which defines itself differently. But one of the things that we do is speak out when we see instances of overreaching by the executive. And so it was my job to write letters to presidents of countries like Yemen. And it was wrenching when we in the Federal Judges Association in the United States received that letter from the International Association of Judges about a year and a half ago saying, we are concerned about instances of disregard for the rule of law.
Okay. Let me go to a question from the audience, and I'm going to ask just one of you to respond. And the question is basically, why have bar associations or judicial associations not spoken up more to defend the judiciary, but also about preserving the rule of law? Seems like they may have abandoned some of their roles. Does any one of you want to accept that?
Not all of them have. Some of them are more restrained than others, I think, but there is sometimes a reluctance to separate yourself, make a target of yourself, and I think some of it can be that concern. Some universities have responded that way. I don't know that I would, if it were not for my institutional role, I'm not sure I would step forward and speak out. But the question that the actor has to ask themselves is, how much is too much? One of the things that our coalition does is to speak to business groups. And we have heard the reaction, well, we're not so bad off. You know, we're pretty much taken care of. We're not all that unhappy. We're doing okay. So why should we be upset? And I think, well, it's wonderful that you feel that way and that you're doing so well until you don't. And then where do you go?
Anybody else? Well, then, here's another question, and I'm not sure I agree with the premise of the question, but I'll ask it anyway. With the respect of the erosion of courts' independence, should federal judges continue to have lifetime appointments? Judge Donald?
Having been appointed to 2 lifetime tenured positions, you know, when I think back about the civil rights movement, and we've talked about that a lot, if those judges, and I'm not saying that judges at all levels do not have a commitment, but one of the things that federal judges had back during that time, when they were faced with tremendous ostracism, isolation, threats, and all of that, was the knowledge that they had institutional protection. They could only be removed from office through impeachment, and you don't get impeached for an unpopular decision. They had to stand up and exercise courage in very difficult times. When I have stood for election, my first judgeship was elected, and I know now that judges who are elected become, as Judge Duncan said, sometimes more vulnerable. People are filing lawsuits, organizing threats. Here in Tennessee, on the Tennessee Supreme Court, a Supreme Court justice some years ago, Penny White, entered a concurrence in overturning a death penalty case. She didn't author the opinion, she just concurred in it and gave the person a new trial. There was organized opposition to her, and that organized opposition resulted in defeating her in the election. A person who is, let's say, wrongfully convicted and is languishing in jail, if in fact judges can be threatened so that you cannot exercise the independence that you can, and independence does not mean lack of accountability, but it means being able to do your job even in difficult circumstances. I think those are the kinds of things we hope that every judge will say, regardless of the consequences, I am going to follow the law, I'm going to apply the law, I'm going to do what my job requires. But as Judge Duncan said, what if that's not the net result?
I'm going to add something to this, just a history. So in the Declaration of Independence, there is a long list of grievances against the king, 30-odd grievances. You know what one of the grievances is? That he appointed judges who didn't follow the law. They followed what the king told them to do. And that's in the Declaration of Independence. So this is the context in which the Constitution is being written. And there was a big fight, actually, between Hamilton and Madison. They fought about a lot of stuff, but they fought about life tenure for judges. And so the decision to have life tenure for judges, it turned out the way that it did, and federal judges have life tenure. But this is why. It's because it's just what Judge Donald said. The king cannot make the decision. You have to have, the judge has to have some protection when you're talking about cases of the magnitude that come into federal court. So I think the answer to the question is yes, it's still justified.
And I know, just one other quick thing. I want to encourage people here, too, to go back and read about the history of judges during Nazi Germany and look at what happened with the judiciary and what the government was able to do when they didn't have a judiciary that was functioning and who stood up against that kind of oppression.
Okay. We're running up against the end of our hour. I do want to ask each one of you to give us one takeaway from the issues that we've been talking about the current issues with attacks on the rule of law. What is the one takeaway that this audience, a lowly journalist like me, what can we do to sort of fight back, to help you all fight back against what is clearly going on now in, to me, much broader ways than what was going on during the civil rights movement, in my view. I'm going to start with you, Judge Duncan. What is the one takeaway that for us?
Be aware. Be aware and be informed. You might not have noticed before Judge Fogel described the phenomenon, but every time a hearing is set, a deportation hearing is set, 2 days earlier, the defendant is moved. Pay attention. Those things, they're cumulative and they matter. And I can't say that strongly enough. It's like telling my stepson, whenever if an police officer stops you and comes up to the car, you should ask, what is the probable cause for this search?
And he'll say, what? Judge Vogel.
Well, Amelia, I really agree with what Judge Duncan said, but, you know, cynicism is very fashionable right now, right? It's easy to be cynical about just about everything, right? And I don't think we should be cynical about our federal courts. You know, when we've done our international work in the past, you know, our federal judiciary was literally the envy of the world. This is not a chauvinistic thing to say. It's true. I don't think it's true anymore. And I think one of the reasons that it's not is that it's been weakened, it's been attacked, and there hasn't been the robust defense of it that there needs to be. But it's a gem. It's something we really ought to be grateful for. We really ought to defend and talk to our friends about it, talk to our communities about. And this is not to say that I think every federal judge is a great person. I don't think that. I've known some that I don't feel that way about. But the point is the institution is a real treasure in our system. And you just remember the Declaration of Independence. I think that's where it all started. And that's, you know, 250 years ago, right? So that's my last thought.
Judge Giles.
Not all judges are federal judges. So all judges, state or federal judges, are bound by the same oath and are to be held to the same standard. And silence is what the political world depends on in order to try to erode those protections that are, you know, burrs in the side of expediency. So don't be silent, be educated, be informed. You know, sometimes it's hard to act as an individual, but as a group of people, you could have an influence. As an individual, you can have an influence. But the more people who stand for the principles that are essential to our governance, to our democracy, the better.
Okay. Judge Doan, you get the last word on this one.
Thank you. What I would say is that preservation of the rule of law is not a spectator sport. One thing I would ask you to do is to be an upstander and not a bystander. I want to invoke the words of Dr. King here tonight because he reminded us that our destinies, all of us, our destinies are inextricably intertwined. We are bound together in a single garment of destiny. He also said that the arc of the moral universe is long, but it bends toward justice. It doesn't bend of its own volition. It doesn't bend of any gravitational force. It only bends because men and women of courage, men and women of commitment, men and women, boys and girls of vision apply their hands firmly to that arc, and they push and they pull it in the direction of justice. Find your place on the arc and push and pull, even as these historical figures we see here have done. That is what is going to keep the foundation of the rule of law enduring. Thank you.
Very well said. You know, I said at the outset that I covered the federal courts for 7 years. I was a young reporter back then. But it was the best education outside of college, and probably including college, that I got during my career as a journalist, because I learned so much about the rule of law, about fairness, about justice, about giving everybody a voice to be heard. And the one thing that I will never forget from my years of covering the federal court were the last sentence that the bailiff gave every morning for the court session. She or he would always say, "God save the United States and this honorable court." And that is a line that has stuck with me for this long, because We have to save this court, because if we don't, we are in big trouble, as you all have said. I want to thank again our panelists, Judge Bernice Donald, Judge Allison Duncan, Judge Jeremy Fogel, Judge James Giles, for a wonderful discussion tonight. Let's thank them again. Now we have Vida Ajamu.
Hello, everyone. Thank you so much for being here with us today. I'm Vida Ajamu. I serve as the Chief Engagement Officer here at the National Civil Rights Museum. I've had the pleasure of doing that for about 15 years now. It's super important for me to do this work here. Tonight reminded us that the judiciary has been central to the civil rights movement in helping to turn courage into constitutional change. We are deeply grateful to our panelists for their insight, leadership, and commitment to the rule of law, and to our moderator for guiding such a meaningful discussion. Please, well, we've applauded them already, but you know what? I think that they deserve another one, and all of you. So I say all of us deserve a round of applause, because we are all doing work to drive change, and we must continue to do that. Before you leave, please scan the QR code. You see cards that's in your seat. It's on the screen as well. And complete that for us for post-survey feedback. That's super important, so that we know what type of programming that's important to you here at the National Civil Rights Museum. If you don't have a card, we can make sure to get one for you. Also, there's an opportunity to share reflections upstairs in our guest lounge. And after this event, following this panel discussion, there's light refreshments outside. We would love for you to stay and continue the dialogue. It's super important for us to not only have these discussions on the stage, but also to continue to have conversations, because there may be a conversation of a lived experience, or a conversation or a question of someone in here could answer that. We want to make sure that we are engaging with one another, and we will do that until about 7:45. Again, thank you so very much for being here. Good night.